Welcome everyone. And while everyone is kind of waiting for others to join, we'll start just a minute or two after 10 a.m. We have a question for everyone. And if you could type your responses into the chat box. And the question we'd love your thoughts on is, what are the biggest challenges and or questions you are working to address when it comes to developing groundwater allocations? So if you can share your thoughts on that, and then we can also use your thoughts, or if you have specific questions during the Q&A session at the end. And I won't be monitoring the chat box the whole time, but I did just see a question pop up. We are going to be recording this and making this presentation available afterwards, and I'll mention that again when we start. Okay. So don't be shy. Yeah. If you have any thoughts, you can type it into the, okay, good. Perfect. Thanks to Josh for the first comment of the day. Anything, how does everyone want to get started? Just so we make sure to have enough time.
I think we might as well.
Okay, perfect. Well, I want to welcome everyone to our webinar today. It is a real pleasure to have everyone join us. Our presentation, our webinar is titled Navigating SGMA Groundwater Allocations and Minimizing Risk. And before we begin, I want to let everyone know that we are recording the session today, and I'll provide those links of where you can get that recording at the end of our session today. And for those attorneys who are joining us, we will also be providing the CLE code during the Q&A session, so look out for that. My name is Christina Babbitt. I'm with Environmental Defense Fund. I manage our California Groundwater program, and I'll be the moderator for today's session. Also with me from EDF, I have Rana Kelly, who heads up our communications for our Western Water team. And she's going to be helping make sure that this session runs smoothly. So a big thank you to Rana. And before I introduce our panelists, I just want to do two things. I first want to make sure to thank the Water Foundation for the support that they provided to EDF as we've helped drive some of this work forward that we're going to talk about today. And secondly, I want to say just a few words to help set the context for our discussion today. So as many of you are likely experiencing firsthand, California's Sustainable Groundwater Management Act is changing and will continue to change the way that groundwater is managed in California. And one of the biggest questions and challenges to implementing SGMA is this two-part question of, one, who gets to pump groundwater, and two, how much do they get to pump? And there's no easy answer to this question. As local groundwater agencies and others work to develop groundwater allocations, they face a major constraint. They cannot change groundwater rights or water law. And even though this question around how to devise groundwater allocations is riddled with legal complexities, and I would say a fair amount of uncertainty, we still need to find a path forward. Because devising groundwater allocations that respect the law and that diverse stakeholder groups buy into is really at the core of building resilient water systems across California. So to provide more clarity to groundwater agencies and others, we've spent the last year and a half diving into this topic, and we've worked with 4 leading California water law experts. And the result of our collaboration is a law review article that was published this month in UCLA's Journal of Environmental Law and Policy, titled The Sustainable Groundwater Management Act and the Common Law of Groundwater Rights, and finding a consistent path forward for groundwater allocations. So in this paper, we offer some recommendations on potential paths forward in navigating groundwater allocations under SGMA. And our panelists, who are also authors of the law review article, will touch on these recommendations in their talks. So without further ado, I want to introduce our esteemed panelists, and I'm going to introduce them in the order in which they will present. We first have Leon Szeptycki. He is the Associate Director of the University of Virginia's Environmental Resilience Institute, And many of you may know Leon from his time at Water in the West when he was the executive director, and Water in the West is at Stanford University. And we also have the pleasure of having 3 practicing California water attorneys with us. Valerie Kincaid, who is a partner at O'Loughlin and Paris. We have Russ McGlothlin, who's an attorney with O'Melveny and Myers. And we have Eric Garner, who's a managing partner at Best and Krieger. The attorneys on today's panel have many decades of experiencing practicing water rights law with a focus on surface and groundwater issues and advising clients on SGMA implementation, just to name a few areas of expertise. Today, each of our speakers will give brief presentations. Presentations in total will last around 35 minutes. And then we're going to spend a good portion of our time together discussing questions and answers or feedback that you may have or comments. And as many of you probably know, the groundwater allocations is a really timely topic right now. So we're hoping that you feel comfortable asking your questions. You can type in your questions in the chat box, or if you want to ask your question anonymously, you can use the Q&A box at the bottom of your webinar screen. And so feel free to type in these questions throughout the presentations, but we are going to hold all questions until the end. So before I turn the virtual screen over to Leon, we have one polling question that we'd like to put up to help to better get to know our audience. So if you could please take a minute to tell us what your current role in SGMA implementation is, and you do have the opportunity to select more than one option. And so we'll leave that poll up for about 30 seconds. And then I think actually everyone can see the polling results.
Are you guys all seeing it okay?
Yes, I love seeing the bars go up and down real time.
Yeah, it is pretty cool.
Okay, it looks like they're starting to stabilize. It looks like we have some folks hoping to get the CLE credits. We have a lot of legal counsel on, which is great. You guys are going to be the ones intimately involved in some of the questions that we're going to be grappling with today. A fair amount of water managers, public sector employees, and private sector employees.
Someone is saying they're not seeing the poll.
Maybe you can just, if you don't see the poll for some reason, just type in what role you're playing in SGMA implementation into the chat box, and we might be able to kind of incorporate that after, and we can send out, maybe there's a way when we post this, we can also post some of the polling results.
Oh, they're seeing the poll, but not the results, Christina. So I think maybe
okay.
just it's because we're co-hosts. But in a moment, we'll share that. Well, I can, we have 154 out of 180. So I can end it and then I think it will show it. Sorry about that.
Okay,
Shall I go ahead and end it? Okay.
Okay, we're going to end 5, 4, 3. Okay, it's already ended.
Oh, sorry.
The polling results.
I'm sharing the results and hopefully it says attendees are viewing it. Are you guys able to see it now? Yeah.
Perfect.
It looks like the most is the legal counsel.
Perfect.
So.
Well, thank you again so much for taking time out of your day to join us. With that, I'll now turn it over to Leon. He's going to provide a brief overview of the law review article, and he's also going to introduce each of the topics that our other speakers will touch on today. So turning it over to Leon. Thank you.
Well, it's great. It's great to be back in California, if only virtually. I was at, as Christina mentioned, I was at Water in the West at the Woods Institute at Stanford when Christina first approached me about working on this issue and trying to pull a group together to look at this sort of central difficulty facing GSAs. And as Christina mentioned, you know, SGMA makes it clear that it doesn't alter groundwater rights under common law, and that GSAs don't have the authority to alter those rights. In fact, the legislature felt compelled to mention it twice in SGMA and then mention it again when it amended the adjudication statute the following year. So the legislature really meant this point that SGMA does not change groundwater pumping rights. But the problem, and I think all of you know this, at the same time, particularly in overdrafted basins, the core function of GSAs overlaps extensively with core issues related to groundwater pumping rights. So setting limits on pumping within the basin, allocating available groundwater among users, enforcing each user's allocation. All of those are central both to a GSA's job in an overdrafted basin and central to resolving common law groundwater pumping rights. So this issue of allocation in particular is what we really honed in on as being both at the core of groundwater rights and at the core of the job that SGMA gives to GSAs, and where the potential between the GSA's job and common law groundwater rights was sort of where that tension was greatest, and the potential for conflict and the potential for litigation is greatest. And this issue of allocation is obviously central, not just to reducing pumping, as I mentioned, but it's also essential to set fees, to fund supplemental water, to fund supplemental sources of water. It's also central to any implementation of groundwater rights. And so the ability of GSAs to perform this allocation task and to do it in an effective and precise manner was really critical. But the central problem with the law of groundwater rights is that it's been announced through a series of California Supreme Court cases, 3 cases really, 4 cases at the most, all of which are subject to interpretation and which as a group leaves significant gaps and significant uncertainty in the common law. So the question that we faced in writing the article is, could we give some coherence to the common law, and not to suggest that it's incoherent, but coherence that's meaningful to GSAs? And could we identify where there is room for the GSAs to operate and where the constraints on GSAs might be, and ultimately try to give GSAs and people working with GSAs a roadmap for developing, first of all, limiting the risk of litigation, potentially avoiding litigation, and then developing a GSP that is resilient to litigation and that will be durable and last for the long term, so that really avoiding a situation where risks under the common law undercut good, sound, sustainable groundwater management. So that's what we've tried to do in the article. The basic outline, it's just really straightforward, everything you need to do to allocate groundwater. So the first question is, what's the supply of water available to allocate? And how do the common law and SGMA differ at all about what that supply is? How much water is subject to the GSA? What's the interaction between the common law term safe yield and the SGMA term sustainable yield? Who can pump that available supply? Second, who can pump that available supply? How much can they pump? And the interaction between GSA ordered reductions in pumping, GSA allocations, and these common law principles that we all love so much of overlying rights, appropriative rights, and prescriptive rights. And then finally, whether there's any flexibility for GSAs allowed by the equitable doctrine of physical solutions, and then the constitutional mandate for reasonable and beneficial use. And so the paper goes into that, and then it also finishes up by focusing on lessons from past adjudications. And in fact, despite the sort of difficult, maybe is the best word, reputation that adjudications have, adjudications, and particularly the settlement of them, have been a fertile ground for creative solutions to groundwater management. So we really tried to close the paper by looking at how GSAs can apply those lessons. So that's really a really quick outline of the paper. It's important just to take a step back and recognize that there's a whole host of issues that the paper does not deal with. So for example, what's the best allocation scheme for creating really good groundwater markets? What are the best tools to bring pumpers together and try to reach groundwater users together and try to reach consensus on a GSP and minimize the risk that somebody will sue? Whether allocation methods that have worked in Southern California and on the coast will work with a sort of different set of actors and a different level of overdraft in the Central Valley. So there's lots of issues like that the paper does not deal with, and it really, as I said, focuses on the interaction between allocation by a GSA and then common law groundwater pumping rights. And so the panelists today, the 3 practicing lawyers, are all going to look at take a piece of the paper and kind of briefly outline it. So Valerie's going to talk a bit about what's the available water, what's the total pool of water available for allocation. And I think she'll talk some about landowner participation in the process as well. Russ is going to talk about principles for allocating water under the common law. And finally, Eric is going to talk about relationships between courts and GSAs and litigation risks, and then insights from other adjudications, insights from the adjudication world that can be applied by GSAs. So that's just a brief overview of what we're doing today. And I think I'll just turn it right over to Valerie to proceed with her part of today's festivities. Take it away, Valerie.
Great, thank you. Thanks, Leon. Can everyone hear me? I'm assuming you can. So I'll continue.
Yes.
Yep. Okay,
Yes.
great.
Yes.
Like Leon said, I'm going to take and expand a little bit, frankly, from the article, but take two of the issues in the article, the safe yield versus sustainable yield, and then the importance of landowner and stakeholder participation when you're talking about and developing allocation structures. So first, the safe yield versus sustainable yield. I think most people know that SGMA defines sustainable yield as the amount of water you can extract from a basin without causing undesirable results in the 6 sustainability indicators that SGMA outlines. That's not terribly different than the safe yield definition in the pre-SGMA days that was defined in cases in common law. And that definition, again, was similar. It was the avoidance of undesirable results, mostly just defined as groundwater levels. A lot of people consider that just avoidance of overdraft or long-term overdraft, if you will. But I think although the definitions are very similar, as we noted in the article, I think that the on the ground differences between those two definitions, when you apply it to an allocation structure, could be pretty different, and you could have defensible allocation structures that look differently under the sustainable yield definition compared to the safe yield definition. And specifically what I mean by that is that I think that previously in adjudications, you had some adjudications group groundwater users into kind of classes. And those classes were based on groundwater right basis. So if you're a prescriptor, or if you're a dormant user, if you're an overlying user, those were kind of classes that adjudications historically identified. I think going forward under the sustainable yield definition and practice of allocations, I wouldn't be surprised if I saw an allocation structure that really honed in, depending on how much data you have, on allocations where if you're really close to a seawater intrusion problem, you might have a different allocation than someone in a basin far away from a seawater intrusion issue. And I think that that's true with all the 6 undesirable result factors. You could imagine a scenario where someone was very close to a subsidence issue, and their extractions may cause undesirable results in subsidence quicker or more directly than someone else in the basin who's geographically further from that area. Same thing with groundwater quality, and same thing with cones of depressions and groundwater levels. And I could really even imagine a structure, if you got very specific, that that based an allocation structure, or maybe even reduced an allocation structure based on representative monitoring wells that have a problem hitting their minimum threshold requirements. So maybe you would have an allocation system where everyone had a specific allocation, but if you were close to a representative monitoring well that kept missing their minimum threshold, maybe that would be taken down. Those are very specific examples, and certainly we'll have to see if they're defensible, because I think that in the previous common law with safe yield, it was a little bit of a broader definition, and I don't think classes were arranged in that way. So we again, like Leon mentioned, a lot of this is, we'll have to see the defensibility, certainly the defensibility of creating allocations based on the 6 undesirable results, or the 6 sustainability indicators in SGMA. You'll have to have a lot of data probably to back that up and make it defensible. But on the ground, I can see where those two definitions may cause some differences in allocation and management. But again, from a definition standpoint, they're very much the same and very consistent. So I'm going to move on to landowner participation. And first, I'm going to talk about why landowner participation and stakeholder participation is important in an allocation structure. And then I'm going to talk a little bit about what happens if you don't have it compared to if you didn't have it previously. It's important for several reasons. Some of them are pretty obvious. One is to avoid GSP litigation, right? We've seen some GSP litigation from the 2020 plans already. I think there are 3 basins who've had GSPs challenged already. So if you have landowners and stakeholders who are invested and feel like they're a part of the plan and feel like their input was considered as it is required by SGMA, you're less likely to have folks come in and challenge a GSP. Very similarly, getting landowners on board will hopefully reduce the likelihood that a quiet title or an adjudication action would be started. There are also some more technical reasons to get people on board. If you get really a lot of stakeholder and landowner buy-off for an allocation program, you're probably more likely to relax the rigid rules of groundwater law. And that might really help facilitate an allocation system. Probably one of the most rigid rules that I can think of in groundwater law is that an overlying water right holder is technically not allowed to use their groundwater right on a different parcel of land. So if you all have that kind of siloed version and that rigid rule applying, it will be maybe more difficult. You'll have a less nimble system. You won't be able to transfer, move water as well. So for folks to buy in the system, I think you'll have a lot more flexibility. Similarly, if you're talking about prescriptive claims, if you can come up with an allocation system that people like that deals with those and kind of enters into somewhat of a settlement of those prescriptive claims, I think you're going to have a lot more flexibility in the allocation system you provide. You can kind of walk away from the rigidity of the rules. And the fourth reason to have landowner buy off is that you need some participation in an allocation system to make it work. So if you only have one person who kind of bought in or is participating in the allocation structure, that one person won't have anyone to trade water with or to transfer water and to move water around. So there's got to be some level of participation where folks are willing to support the allocation system, trade water. You might need people to fund it, frankly. If some of your allocation system includes the option of importing water, sometimes importation of water, depending on where you're at, can be really expensive. And you have to have kind of a threshold participation to fund that. Similarly, for recharge projects, not only might you need funding to get alternate sources of water, but you might also need landowner participation to either apply more water to existing agriculture or to actually have a recharge basin. So you might need landowners to actually invest their land holdings in getting that allocation system, some parts of the allocation structure to work. So what happens if there's not full participation? That used to be an issue that previous adjudications dealt with a lot, right? How do you get the people who are not participating to have an adjudication binding those parties? That was always a huge adjudication issue. I think SGMA has really changed kind of the landscape of that problem. It's not a problem that has gone away completely, but remember that SGMA allows these GSAs to come in and have jurisdiction over their service areas. So an extraction limitation or a policy or an ordinance or an allocation system, a GSA does have the authority to come in and adopt that for its service area. But like any good attorney, I want to caution people that jurisdiction is not foolproof. You can't do anything with that jurisdiction, of course. You still need to have a very defensible allocation structure. And I think this is not something people think a lot about, but I think as we move through SGMA, it will become more and more important, which is this concept that GSAs are have the jurisdiction to manage groundwater, but that's a big difference between a trustee relationship, which SGMA doesn't create. So the GSA is not holding individual groundwater right holders' rights in trust. That's not what SGMA is doing. So because you're able to manage, but you're not holding those rights in trust, what happens if an adjudication does start, if you have an allocation system that people fundamentally do not like, to the point where someone adjudicates the basin, you really have a fairly large role reversal in an adjudication where you, in the non-adjudication world of SGMA compliance, you have the GSAs out front managing. But in an adjudication scenario, those GSAs are allowed to intervene through the streamlined adjudication statute. But most often those GSAs are not going to be actual groundwater right holders. So they're going to flip the roles, and they're going to be sitting much more in the back seat, where groundwater right holders in adjudication are sitting directly at that table. So that's just kind of a check on the jurisdiction. I think that the full participation issue, you're not going to see that as much, but you always have a check on GSP defensibility. So we all have to be careful and make sure that landowners understand what is going into an allocation structure, and that they buy off on that structure. So those are my two topics. I will now kick it over to Russ, and he will take it from here.
Thanks, Valerie. Good morning, all. And I'm going to use a few slides that I think Rona's going to put up to guide my presentation. There we go.
Can you guys see those okay?
They show up on my screen, so I think so.
Yes.
Okay.
Again,
great.
Thanks so much. Allocating groundwater rights, as you can see in this initial slide, can be viewed as a pie sizing and a pie slicing exercise. The sizing is the reduction of the available basin groundwater down to the components that can then be allocated among users for consumptive uses. The slicing is obviously the division of the supply available for consumption among those individual users. For the pie sizing, we need to remove the groundwater that is not available for consumptive use by those with rights to the native groundwater supply. To do this, we need to take out the quantity that must be reduced to achieve sustainability. We also need to take out any developed water, which is non-native supply, and I'll discuss that a bit further in just a moment. These reductions yield a smaller pie, as you can see in the lower pie chart there, of native groundwater available for consumptive use. We can then consider a wholesale division of this native supply, this native groundwater supply, among the two major forms of water rights holders in California: the appropriators, or in some circumstances, the prescriptors, and secondly, the overlying landowners. Next slide, Rana, please. Once we do a wholesale division, we can consider how the portions granted to each pool are divided internally within each pool. As we will see, different legal rules apply to these different internal pool divisions. Next slide, Rana, please. So when we're reducing the full water down to its components for consumptive use and trying to achieve sustainability, obviously the reductions are targeted at avoiding the undesirable results identified in SGMA. But we should also recognize that this is a fluid process. There are additions that can be achieved through physical solutions, replenishment, and plumbing, pumping, optimization, and that it's not static in time, it's adaptive. We're gonna have, in many circumstances, ramp down from some close to current production to a more sustainable, lower amount over time. We're going to have improving technical understandings, new circumstances that arise, and so we need to build in that adaptive management process into our pie sizing and how that affects our division. Next slide. So I mentioned we got to take the developed water out. What's developed water? Well, developed water is non-native water in the groundwater supply. The courts have articulated it as a fruits of one's labor standard. That's imported water, that's water that's foreign in time, or native water that would have been lost but for human investment. If you dam it up and leak it into the basin over a dry period, as they did in Santa Maria, for instance, it's native, but it's only there because of someone's investment. It's not developed water, that is. Return flows from groundwater application or return flows from surface water that would have otherwise replenished the basin. Next slide. So once we've taken that down to a quantity that is our native consumptive use amount, we have these two big buckets of rights that you all probably have heard about. The first is overlying rights. The second is appropriative rights. The overlying rights, they're part and parcel pertinent to land ownership. They are tied to land ownership. They're not defined by historical use per se. And among the overlying rights, the rights are correlative. They're equal in priority. By contrast, you have appropriative or non-overlying rights, and these are typically held by municipal purveyors or folks that are using water off of the overlying property. They're defined by their historical quantity of use on a first in time basis. And importantly, a basic form of common law, they're junior and therefore only entitled to surplus after the overliers have been filled. Next slide. So prescription, that's what we all hear about. That's the qualifier on those two big buckets of rights. Prescription is effectively a legal means, a legal way to take and eliminate overlying rights priority, or at least portion of it. To achieve prescription, you got to show 4 elements: actual use, open and notorious use, adverse use, and exclusive and continuous use for 5 years. The overdraft the courts have found creates the adversity. The notice has got to be at least constructive notice. A reasonable landowner exercising standard due diligence would have to have noticed that the basin was an overdraft and they needed to take some legal action to protect the right. And lastly, the continuous use factor, I would note that it likely means the lowest use in any 5-year prescriptive period, because that's the only use that has truly been continuous for that 5-year period of prescription. Next slide, please. Here's a quick cartoon, makes the point. Typically, overliers are senior to appropriators, but the prescriptor can take a bite out of the overliers and the such. Next slide. However, it's important to recognize that these overliers can protect some of their right through the doctrine of self-help. And this, the courts have said, the overliers preserve some of their overlying right through their actual pumping during the prescriptive period. The pumping itself was a restriction on a complete and total prescriptive acquisition by the appropriators. It's akin to installing a gate across a private road to avoid the development of a prescriptive easement. Next slide. I should also mention very briefly the doctrine of subordination. This is a doctrine that's still developing in the law, particularly in the groundwater context, but if it can achieve a loss of priority of the dormant overlying rights. Those are the rights that are pertinent and part and parcel of the land ownership, but have not been historically used, as opposed to those that have been effectively used or active rights. And so the courts may be able to subordinate that dormant overlying right to presently exercise rights, including presently exercise appropriate rights, which would otherwise have a junior status absent prescription. Next slide, please. It's also important to recognize that the Constitution puts effectively a floor on water rights. The foundation of water law is that we must maximize beneficial use. And so the courts have been clear that while an equitable physical solution, or in our context here, a groundwater sustainability plan, must preserve water rights priorities, it can only do so to the extent those priorities do not lead to an unreasonable use or violate this maximizing beneficial use. So the takeaway: must follow water rights, but not to the point that we violate this golden rule of maximizing beneficial use. Next slide. It's also important to understand that equity matters and equity will play a role. The courts possess broad powers to see that justice is done and to try to achieve a fair and just solution. So while water rights are very important, you should always appreciate that the courts have equitable tools in their toolbox to achieve some form of equitable result. Next slide, please. So when we talk about issues between prescriptors and self-help, that portion that we're going to be dividing based on prescription and self-help doctrines, we're going to be asking cases like, is there a case for prescription? Did those 4 elements, were they satisfied? Are we dealing with minor or major prescriptive use? If there's only 10% of the basin production that's been made by appropriators, maximum only 10% of that yield is going to be divided on the basis of prescription and self-help doctrines. And we have to ask, when is the prescriptive period? Is it recent or is it decades ago, which was the case in Santa Maria, for instance? And then we're going to say, how do we divide the water that we are dividing through prescription and self-help between these 2 categories? And the courts have basically said that it's got to be a proportionate reduction or share of the safe or sustainable yield between those 2 categories. Next slide, please. When we're talking about landowners and dividing the pool within the landowners, this is where it gets very complex. The driving force of division amongst correlative rights holders, overlying owners, or riparian landowners in the surface water context is equity. Equitable division is the name of the game, but how we do that, the courts have been far from clear. We've got lots of questions like heavy versus lighter historical existing uses. How do we treat those dormant landowners that's inherent in the right? Does historical use matter? And if it does, how much and why particularly? And then accounting for various equitable claims, use of surface water in lieu of groundwater, should they get an allocation of groundwater supply? Crop idling or substitution during some period of time, does that count? Conservation. And then how do we deal with allocations to mutual water companies or to their shareholders, and how to, and which gets to hold the rights, how do they hold them in trust, et cetera? All these questions are fertile ground for new decisions by the court. Next slide, please. We identified in the article at least 4 different theories on which overlying rights might be divided: historical production, division across the irrigated acreage in the basin, division across all acres in the basin, or gross acres, or some hybrid. We think that a hybrid is likely the best approach because it pulls on the various legal tenets in the law. Next slide, please. And finally, here is a brief conceptual schematic that kind of shows this division that I'm talking about. First, you got to take down the available water to what is sustainable or safe, a safe, sustainable yield, where they're going to lop off that portion that's developed water. That's going to yield a residual that is your native, safer, sustainable yield. And if a basin has a basis for prescription, we're going to look at that portion, which is going to, of that native safe yield, that's going to be divided on the doctrines of prescription and self-help, and that portion that's going to be divided amongst the landowners based on correlative rights. With respect to the first bucket, some portion of that's going to go to the appropriator prescriptors, some portion of that has been protected through self-help pumping, and then when we get to the landowner correlative right bucket, on the right-hand column there, we might create a dormant land set-aside pool to give some allocation to dormants, or maybe not. And then we're going to take the allocation and divide it. And it says here within it, with existing historical irrigation or other equitable factors that might come into play. I will note that although the law says that historical use is not the driving force per se of equitable division amongst correlative rights, it is a proxy for many of the equitable considerations the courts have risen. So you might look at historical irrigation with groundwater, you might look at historical irrigation with surface water as some equitable entitlement, and other various equitable doctrines that might come into play to that division. Our point here that hopefully this schematic shows is that trying to take a hybrid approach that looks at these various legal tenets is likely going to be the result that does not yield windfalls or wipeouts amongst competitive users, and therefore is likely to achieve greater consensus because nobody is being rendered completely wiped out. And hence it's more likely to both prevent an adjudication because there's very little to be gained by an adjudication in that circumstance. And if it is adjudicated or challenged, it's likely to sustain challenge better than taking a one-sided or far extreme view and not recognizing the other legal tenets that are applicable. Thank you. And I'm going to turn this now over to Eric Garner for his part of the presentation.
Thank you very much, Russ. You did actually get through all those slides in 10 minutes, and credit to you. Well, if this seems like a lot of material and a lot of complex material, it absolutely is. I'm on my 4th groundwater adjudication at this point. I've been involved in a groundwater adjudication every day for the last 28 years, and I've read these cases literally countless numbers of times, and I still find new things in them. So this is really complex material. We're throwing a lot at you at once. We realize that, but obviously time is limited, and we want to give you time to ask questions. And is it hard? Yes, it's absolutely hard. The question that Christina teed us up with of who can pump how much. I can remember in the Antelope Valley case, we had pretty much mediated every issue. We'd agreed on all the easy stuff. We were down to that issue in 2002. As we close 2020, we are almost done with the appellate briefing, and we hope to get oral argument in 2021. That's how challenging this can be. Obviously, GSAs are on a compressed timeline with their GSPs. So it's a long way of saying if it seems tough and complex, it is, but it's water and nothing's more important. So with that, I'm going to talk about GSAs and pumping allocations and water rights, and then I'm going to touch on some lessons from prior adjudications And hopefully I'm doing that in 10 minutes. It would almost be easier to spend 10 hours on this than 10 minutes, but I will try and pack it all in. So it's very clear from SGMA, GSAs cannot determine water rights, right? They can only come up with pumping allocations. And of course, SGMA would never have passed if the water rights system had been changed. So when it was passed, that ambiguity was clear to everyone involved. And at some point, this issue, governance issue, for lack of a better term, of how GSAs and their pumping allocations fit in with water rights is going to get determined, by an appellate court. That may well be sooner rather than later, because it is a tricky issue. But what we've tried to do in this article is provide some guidance as to how courts are going to look at GSA allocations. And first and foremost, the significance of GSAs not being able to determine water rights means that anyone can go to court and get their water right determined. Everyone will get their day in court. So when GSAs are doing GSPs, they should anticipate being challenged, because occasionally, rarely, there's complete agreement, but that is the exception, certainly. And so then the issue is going to come, okay, well, let's suppose this is the pumping allocation and someone goes to court and the court determines the water rights are somewhat different. How is a court going to look at that? And Russ just did a great job of walking through the California water rights priority system. But as I like to say, in California, we start with priority, but we rarely end with priority. And that is because there are two doctrines, and they've been touched on before, but I'm going to amplify them a little bit. The first is in the California Constitution, Article 10, Section 2, and that's the doctrine of reasonable use. And reasonable use is the cardinal principle of California water law. So it basically sits over priority. Court will look at priorities, and then it's going to determine if those priorities are reasonable. The second one, which I'll touch on in a moment, is the doctrine of physical solution. So there's nothing new about reasonable use. Article 10, Section 2 was adopted in 1928, been the law of California ever since then. Priorities have been modified in any number of water cases since then, especially groundwater cases. Reasonableness is tricky though, because while water rights priorities, at least to some degree, can provide absolute certainty, first in time, first in right, at least if you're operating under the appropriative system. Reasonable use doesn't provide that level of certainty, because the courts have been very clear what is reasonable depends upon the facts and circumstances of each case, really each basin. And that can also change over time. And the reality of that is that's because water conditions change over time. Water moves, water gets pumped out, the amount available decreases, and societal needs change. If we operated on a pure priority system in California, once and for all, we might still be a mining state, because mining is where water use started in California. And then it was agriculture, and then it was about water being divided between agriculture and urban uses as the population of California has grown so dramatically in the last 100 years. So reasonable use is the cardinal principle and the standard that courts will look to determine if a pumping allocation that is different than a water right, obviously if they're identical, then you're going to be fine. But if the water rights determined to be different than the pumping allocation, our best view, my best view, is that the court will be looking at it with a reasonableness standard. Does it deviate too far from the water rights priority to be unreasonable? And courts, as Russ noted, sit in equity in these cases. And that's lawyer speak for saying they have the power, they can use their powers to get to a fair result. So courts always look at water rights cases through those eyes. And the doctrine of physical solution, which is called a common sense approach to water rights, gives them the power not only to modify priorities, but occasionally to order projects and things like that to make water use more reasonable or fit within that reasonableness standard. So the court will look at the water rights priorities, compare that to the pumping allocation, consider it under the doctrine of reasonableness, look at the doctrine of physical solution and see how they may be able to make pumping uses fit within that and come up with a determination. But again, the overarching standard is reasonableness. But until there's some case law on this, obviously SGMA is just being implemented, so there is none. All you have are lawyer opinions. Until there's case law, there's going to be uncertainty surrounding this. And frankly, because of the doctrine of reasonable use, there will probably be continuing uncertainty even after we get some court decisions, but at least there will be some guidance points going forward. And then second, I wanted to talk about adjudications, just making sure I'm staying with my time here, and what lessons can be taken from adjudications. I've been through Mojave, Santa Maria, Antelope Valley. I'm now in another adjudication. Unfortunately, there are probably more on the way. And I guess the overarching lesson is not a legal one. It's a practical one. Be prepared to spend a lot of money and to not get exactly what you want, because that is generally, it's always the way adjudications go. Nobody wins 100%. As Valerie noted, the Streamlined Adjudication Act should speed them up. Determining basin boundaries and finding and serving all the parties consumed years in some of the cases I was involved in. That is quicker under the Streamlined Adjudication Act, but still there are complex cases for judges to deal with. There are complex cases for the lawyers. Usually if somebody files one, they're benefiting from maintaining the status quo and slowing things down, and it's easy for lawyers to slow cases down. So it will take time nonetheless, and they are expert intensive because this is about hydrology and it's about water we can't see, and they're lawyer intensive. So in a mediation last week, 2 weeks ago, you got 20 lawyers on the screen, and that can be low in these cases. There are always a lot of lawyers and engineers involved. Process is so important in adjudications, and I'd say so important in GSAs and GSPs. So I think that's a key lesson, giving everyone a seat at the table. And that would include disadvantaged communities. That's something that frankly, rarely, if ever, have had seats at the table in the adjudications I've been involved in. That is something GSAs should be paying attention to as they do their GSPs. But in basins that are in significant overdraft, there's going to be either economic cost or people are going to have to reduce their pumping. If there's any chance of getting consensus on that, it's only going to be with people participating and getting their ideas heard. So process is key, starting with the technical issues, because often experts can agree on a number of things hydrologically. I mean, there's only a certain number of parameters that influence how much groundwater is going into a basin and out of a basin on an annual basis and over time, and how much is there. And often experts can agree on 75, 80% of those. And then there has to be a fight down the road. It's at least going to be limited to those parameters. So I think, for GSAs and using all the technical resources available to parties in the basin is a very valuable thing, because at least you can identify where the some issues are going to be, whatever that hydrologic parameter may be that there's widespread disagreement on. So I think that's starting the technical issues is key. Allowing time to implement, Russ mentioned the concept of ramp down. Courts, to my knowledge, have never required people to go to safe yield, which is what's been the case in adjudications, not sustainable yield, to safe yield immediately. They've usually allowed a ramp down period of time, often 5 years, occasionally longer, with a reduced amount of pumping each year or payment. Either it is buying imported water or it's reducing pumping. And one has to start somewhere, usually, and it's usually current pumping. And even if there are differences in the basins, we lawyers love to think of basins as a big bathtub. It's very convenient for us, but they're not, and they act differently depending on how pumping is going. So reducing pumping, monitoring the basin, doing the adaptive management like Russ said. But sometimes even if one part of the basin, one sub-basin may be in worse shape than another sub-basin, you start everyone in the same place and move them down at the same rate. That's what we did in Mojave, knowing that one basin was going to have to continue to go down long after the others. So just some common sense sometimes helps on these things, and flexibility in that process of implementation. And I want to mention transferability, which is something that Russ talked about. When we're dealing with overdraft and overuse of a resource, if there's going to be a substantial reduction in use of the native water, then either it's going to cost more for supplemental water, or it's going to require someone's livelihood to shift in a substantial way. And one thing that has been done, as Valerie noted, under the common law, you can't transfer an overlying right to an appropriative use, often ag to urban, without losing the priority. That's not a common law right. However, under adjudications, that's been done. GSAs can do that, and it gives people an opportunity to transition from what they're doing to doing something different. And there's still going to be economic pain, but at least it minimizes it to some extent. However, I do want to caution one thing there. Sometimes there's a sense, if say a basin is urbanizing, it's been farming, and the cost of water is going to go up, and the farmers are going to be moving out. They're expecting this financial windfall because their overlying right has a priority over the appropriative right. of the public water supplier. Again, courts sit in equity. They're certainly willing to allow financial benefit to parties that are having to shift, out of their business, but the massive financial windfall, in other words, absolute priority, has not been allowed in these cases, and I don't think it would be or will be in the future. So again, as I said, where this started, if you go into an adjudication, and so I think about this if you're participating in a GSP process, trying to get the GSA to be reasonable, it's going to be better, because at the end of the day in the adjudication, you're not going to get all you want, and you will spend a lot of money doing it. So again, process-wise, much better if the GSAs can be flexible, work with the stakeholders, develop a GSP that hopefully most of the basin buys into, and then the challenges are limited. So with that, I will hand it back to Leon and Christina. Thank you very much for attending today.
Thank you so much to all of our speakers. We really appreciate it. And I just want to say thank you to all the co-authors on the paper, because, it wasn't a straightforward process. There were lots of hours spent on the phone debating different topics and kind of coming together to really think through what a better path forward might look like, or what recommendations we can provide. So much thought and time went into the paper and, in the presentations today. And I'm just so thankful for all the expertise that everyone really donated and dedicated to, the last year and a half of the process. So thank you. And with that, Leon and I have been behind the scenes trying to compile questions. We're going to do our best to try to ask those somewhat in the order that they have come in. In some cases, we've tried to maybe combine questions or kind of tie questions together. And in order to make sure that we can get through the majority of the questions that have been posed, we're going to try to pose questions to specific panelists so that they can respond to. And if other panelists feel like they have to add in a different point, which I suspect will happen in some cases, we can go ahead and do that. But I'm going to turn it over to Leon to go ahead and ask the first question, and then we'll just rotate asking questions and hopefully have a great discussion today. So thank you.
Yeah, and so the only two things I'll add to that is there are a lot of questions, and I'm sure we won't get to all of them. So I apologize in advance for the questions that we don't get to. The other thing I'll add is that I think to keep our practicing lawyers from being put too much on the spot, we're going to generally avoid really direct questions about specific adjudications. There might be questions that allude to specific adjudications, but aren't necessarily about those specific cases. So, and by specific adjudications, I mean ongoing adjudications. So the first question I'm going to ask, which I'll ask of Valerie, is whether if a GSA is doing an allocation, whether it will improve the legal foundation, the legal footing of that allocation if they're tied to multiple undesirable results, such as avoiding surface water depletion, mitigating seawater intrusion, et cetera. Does the mitigation of multiple undesirable results improve the sort of legal security of a groundwater allocation scheme?
Thanks. I think so. I think that question really goes to kind of defensibility and data. So if you had an allocation that reduced someone who, an extractor who happened to be, creating a cone of depression, so you have a groundwater level issue. They also happen to be right on kind of a seawater intrusion and a groundwater quality issues. I think you had data to back up that extraction caused a huge amount of undesirable result exposure. You probably would have enough technical data to say that reducing that allocation, again, not immediately, but in the long term, was necessary to get to sustainability as SGMA defines it. So, I think that you would be more defensible if you had all of that data, but it's going to be data, and it's going to be, like Eric said, courts applying reasonable use. Is it reasonable to use water in a location where you kind of get into a lot of SGMA issues, and that one extraction hypothetically causes undesirable results in 6 of the sustainability indicators? I think you probably are well backed up into saying that allocation or setting that allocation lower. And the question really is it reasonable to use water there compared to other places in the basin? For folks that like priority and like what they're doing, that's going to be a tough pill to swallow. But I can see a GSA backing up that kind of allocation and that different allocation based on that measure.
Great, thank you so much, Valerie. And the second question is going to be to Russ, and I'm going to apologize if this was covered in your presentation because I was trying to compile questions. So the question is, what are fair allocation amounts for de minimis users generally, including for future growth to make sure that drinking water needs are met? I'm assuming you probably can expand upon that, Russ.
Well, we all know that SGMA authorizes a de minimis allocation at 2 acre-feet. The adjudication reform law passed a year later actually acknowledges that up to 5 acre-feet can be left out for of the adjudication from a determination of their water rights, but the courts have the power to void that if it is going to amount to a significant use. The whole concept of de minimis use, and that really should be separated to some point from domestic well use, is the de minimis use is so small on an individual basis, unless you amalgamate so many individual users, it's not going to move the needle in terms of sustainability. So we can accept it from the basic allocation regime, and that's been done in many past adjudications. And I'm sure many of the panelists can think of others. Seaside is one that comes immediately to my mind, and 5 acre-foot de minimis pumping exemption. The domestic well owner use, that's a really important issue. And it really goes to this equitable issue that we mentioned and the court's power to do equity. And it's going to have a couple different breaks. One, rendering rural, sometimes, disadvantaged communities relying on rural domestic wells. Those have to be protected. Often, unfortunately, they're the most shallow wells in the basin. And so you may not want to manage overall the entire basin to those shallow wells, may not be what's in the grander scheme of optimizing the beneficial use of the resource. So you might need to find a physical solution of tapping them into deeper wells, even drilling them a new deeper well, connecting them to surface water purveyors, some way to combine protection of those interests, particularly if they're disadvantaged interests, with the interest of maximizing the beneficial management of the basin.
Awesome, thank you. I think Leon's going to ask the next question.
Yeah, thank you, Russ. This question is for, sorry, I have to track down to it. This question is for Eric, and I think it will win the prize for the biggest disparity between the length of the question and the necessary length of the answer. So the question is in whether in the SGMA process or the adjudication process, the question isn't clear, but I think obviously both are relevant. How do you address tribal and military water rights and uses? And then I'll just tack on to that, how to address groundwater dependent ecosystems. So Eric, why don't you run with that one?
run from it or run with it? Let me take a couple of those. The water dependent ecosystems, it was addressed in Mojave with regard to particular fish. Often they have not been addressed, to be frank. So, but that is something I think in light of what SGMA says about the relevance of those things that courts will look at if there are those ecosystems in the future and in adjudications. But again, what's historically been addressed in adjudications is the parties who were there. The Department of Fish and Game was active in Mojave, so it's a reasonable use. Water is going to have to get allocated to it, and that would probably wind up being an engineering issue. I've not encountered the tribal rights issue, but I have encountered the military rights issue. It's a challenging one because, and it actually can depend on a couple different things, but there's a federal reserved right. So when Congress, passes a law that reserves a particular piece of land, say for a military base in Antelope Valley, we had Edwards Air Force Base, they automatically reserve the amount of water necessary for the primary purposes of that reservation. And these are things that are somewhat defined by case law. The only way the United States can be a party in California state court is through something called the McCarran Amendment, which means that if you sue every claimant to a water right in the basin, then the adjudication is comprehensive, and the United States can be typically dragged kicking and screaming into state court, and the court has jurisdiction. But normally the problem is here, normally state courts do not have jurisdiction over federal entities, tribal lands, or military reservations. So, to the extent they are subject to reasonable use is probably also a debate, although there's a federal doctrine of beneficial use that includes reasonable use. I think it's fair to say they are, but those are difficult issues. And I think the best one can do if they're not at the table, which they don't have to be under SGMA, is to try and allocate a reasonable amount of water to them under the GSA. Again, in the context of California law, and if they're going to challenge it, they're going to ignore it. They're going to do that. They're not going to challenge it because they're not forced to comply. And that would be my answer.
Thanks, Eric. Well done.
Perfect. Thank you. Okay, so our next question is going to be to Valerie. And so I'm going to interpret this question and we'll see where we land. But I think the question is getting at, what should the sphere of water extraction be to set recharge boundaries and basin jurisdictions? And I think that question's getting at, you have so many management entities, local groundwater sustainability agencies that have formed under SGMA. But obviously you have to manage towards the larger basin. So what does that look like when, setting some of these rules?
Yeah, that is a very tough, it's a very tough question, and it's on the ground, it's going to be difficult to do. I know there are specific GSAs that have kind of created allocation structures for their specific GSA, and they're in the middle sometimes in a larger subbasin. And certainly the question from a legal practitioner's point of view comes up, which is, if common law rights are by subbasin, how does that little fractionalized allocation system work? And I think that the question has to be, how does that work in the larger GSP? It can largely be addressed in coordination agreements, hopefully, and between and amongst adjacent basins. The concept that you can't have a GSP or a plan that adversely affects each other. So I think the real answer is you're going to have to communicate, and you're going to have to talk about how those allocation structures, if developed on a fractionalized basis and not a sub-basin basis, works with the larger GSP. I think it's possible to have a GSP and to have 2 or 3 different allocation systems and fractionalized GSAs, but there's no doubt the tension, of course, from the beginning of SGMA of should we do this on a sub-basin level, or should we allow locals to kind of manage at a more localized level? That's going to come up in spades in these allocation structures and how they work. And frankly, whether you have your fellow GSAs in that sub-basin challenging the different treatment of an allocation structure next door. So you're definitely going to have to talk. You're going to have to convince folks that your structure, if you have one, is consistent with the GSP and also consistent with the other common, groundwater right holders. So, it's going to be a challenge, but certainly a lot of discussion and hopefully a lot of transparency.
Perfect. Thank you.
There was one quick question, which I'll just answer quickly, and then I'll ask Russ a question. Somebody wanted to know what the 3 historic California Supreme Court cases were that we referenced. And it's the Pasadena case from 1949, the San Fernando case from 1975, and the Mojave case from 2000. And Russ, the next question, it relates to a topic that didn't really come up in the paper, but I'm really interested in what you have to say about it. What the questioner asks is that expresses the opinion that they're not seeing GSAs sort of develop enforcement policies, and SGMA provides for it, but again, in this, the asker of the question is concerned that it's not being addressed. And the questioner says it seems that this is critical to an effective GSP. And I'd be curious what you think about the role of enforcement in having an effective GSP, and how you see that being developed in the GSPs that you're working on.
Sure. I mean, it's a great question, and it's an obvious answer. You know, as important as allocations are to balancing the cumulative extractions for sustainability, to achieve markets, to you know, trend the water use to optimal use, so is enforcement. If you don't have, you have allocations without enforcement, you really don't have allocations from an effective standpoint. You know, I think you all know that SGMA provides those tools to sustainability agencies, and you know, they you know, all the way up to prosecution, like any other agency in their rules and ordinances. I would also note that that might turn out to be a complex case in some of the groundwater sustainability plans. Might be one reason, and I don't want to freak anyone out, but one reason that you might look to taking a consensual GSP like is being done in Borrego and flipping it into an adjudication and garnering as what we call a friendly adjudication colloquially in the water industry, and garnering the powers of the court to be an ally and a force to achieve that a necessary enforcement and record keeping and you know, abidance with the rules and regulations you set. And on that point, I would just very quickly point out there is a fundamental difference between a contested, let's get all the experts out and fight it out in court, contested adjudication, and a friendly adjudication where you agree to the rules, sign a settlement, and then take it to court after, as asking the court to stamp that settlement. That's what's being done in the Borrego Basin.
Perfect, thank you, Russ. So the next question I'm going to ask to Eric. It's kind of a statement. I'll add, you know, just an initial thought, and then I'll turn it over to you. But one of the comments or concerns is that, you know, somehow allocations take something away from people, and that's a feeling, you know, on the ground. And you know, it's interesting because I've had some conversations lately where there are folks who are actually moving towards wanting allocations because they want that certainty, right? And so just, you know, tell me what I have to work with, and I'm going to manage. And obviously, the answer, you know, and how much you get and how can you use it obviously comes into play there. But I'm curious if you have any thoughts in terms of, you know, how are you seeing that question kind of play out, and do you have any thoughts around it?
Well, I think, yeah, I've certainly seen that play out over the years. And I think that's where, you know, I mentioned the technical issues up front and the consensus issue, because if there's not general agreement that the basin is in overdraft, and again, basins aren't uniform. So some people's water levels may not be dropping when levels are dropping somewhere else dramatically. And so just because water levels are static somewhere doesn't mean the basin's not in overdraft. But if people don't generally agree the basin's being overused, then it does feel like something's being taken away. I mean, it's tough enough even when the basin has been overused and people, you know, are having to change behavior, either pump less or pay more. So while that feeling may never fully go away, I think the place to start with that is if it's possible to reach some level of technical consensus that there is a problem here, and thus we have to address it. I mean, the last thing I'll say is this is why groundwater is so tough, because if people are taking water out of a reservoir and they look at it and it's a severe drought and it's going down, everyone understands they have to conserve, right? That's human nature. We can't see groundwater overdraft. It makes it a lot tougher.
Thanks, Eric. This is a really, I'm going to read the question, but I'm going to add a couple of bits of my own spin to it because I think it's a really interesting question. The participant asks, Valerie discussed, and I'm asking you, Valerie, Valerie discussed potentially allocating lesser amounts of water to extractors that impact sustainability indicators. Is this addressed under common law? And I'm going to, add to that. I think it is, and this is a great follow on to what Eric just said, is there may be individual pumpers who are having a greater effect on, for example, surface water flows. In order to maintain surface water flows, you may need to cut back on them more than on other pumpers. And what are your thoughts about that scenario? The other interesting question that this raises for me is whether, if you have any thoughts about GSAs that are concerned about users that have a high level of historical pumping, that have done a lot of pumping recently, that may not be, it may be technically reasonable and beneficial, but the GSA may consider it to be kind of profligate or wasteful, and whether there are legal grounds to allocate those users something less on a basis of something less than their historical use, to sort of, for lack of a better word, punish them for wasteful use in the past.
Yeah, that's a great question. And there's common law, probably not directly on point, but I think the unreasonable use umbrella or kind of overarching analysis that Eric had mentioned and that is done in common law does address, I guess, analogous scenarios. So I don't think that in common law there's a case that says, now because this is all new, right? We now have these 6 sustainability indicators and we're managing to those. So I don't think that obviously a case has not looked directly at that, but I think cases have definitely looked at whether a use is reasonable. And the situation where the facts and circumstances of how you determine if a use is reasonable or not changes. And certainly Sigma is going to be a huge change in that. So if you have a user, who you cannot get, is constantly causing a minimum threshold to be violated for seawater intrusion because they're right on kind of this salinity line, I think the GSA is going to have their hands tied and they're going to say, listen, this is just in historic years, maybe it wasn't unreasonable, but that extraction now is, because it's continuing to have us violate Sigma. So I do think that there are common law tools, this whole reasonable use and what that is today and what that will be going forward in Sigma that we can draw on. I think your second part of your question about high water users, historically, I don't love the reasonable use metric, because I think that people get really worried that now they're not going to be able to grow what they want. I mean, I hear that from farmers a lot, which is, wait a minute, so now someone's going to tell me growing, a row crop compared to a permanent crop is reasonable or unreasonable. That seems very draconian. It seems like in today's world, that's very controlling. And now someone's going to tell me which crops are reasonable and not. I don't love that application, because it really does seem to be very controlling of people's how they practice farming and how they do other things. So I think it's not going to be that specific. And I don't think you're going to get into people's, you can apply water right here, but not right here. But I think there's no doubt that the reasonable use doctrine is going to be fine-tuned and people are going to sharpen their swords and shields. And that's going to become a huge issue. And how far that goes, right? I mean, can you grow a tomato, but not a carrot? That seems crazy to me, but certainly it seems less crazy to say you're in the middle of a cone of depression and your historic pumping has really put you right in this issue. The other folks in the basin can help you out a small amount, but it's really your pumping that's going to have to be addressed to get you out of that groundwater level issue. That seems more reasonable to me.
Thank you, Valerie. We're going to ask just another question or two, and I want to leave 5 minutes at the end just for some closing comments from all of our panelists. And I also want to acknowledge that I didn't put up the second polling question because we had so many questions coming in, so that takes it's more important. And so it's no surprise the next question goes to Russ, because we're going in order here. And the question is, do you recommend that GSAs determine the allocation and then let some time pass until implementing a market?
Sorry to interrupt for 1 second. Oh, just before you start, I'm just going to put up the continuing education code really quick, because I'm sure some people are interested in seeing that too. So I'll have that up just for a second. Mm-hmm.
Thanks, Ron. And we can put that up, and then Russ, you can go ahead and answer the question while people copy that down.
Yeah, I'm not quite sure how to answer that question. I think it's circumstantial. There may be circumstances where we want to be careful about the effects of a water market, but generally, I think that water markets are a positive, ameliorating tool to the pain that is achieved or endured by having to cut the cumulative extraction and individual extraction and allocations. It allows it, from a societal perspective, markets incentivize conservation because you have another option to use with water you save. Moves water from lower to higher value uses. It reveals the true value of the resource. So generally, markets are, I think, a favorable, good tool. They do clearly have to be regulated or controlled for potential causing exacerbating undesirable results, moving a bunch of pumping to a pumping depression or right next to the ocean in a seawater intruded basin or in a subsidence zone, et cetera. But if you can account for those, they're generally going to be beneficial. And so I think markets should come online in that properly regulated form as soon as possible, but I can probably fathom circumstances where a breather is necessary too before the markets take effect.
Thanks, Russ. And Leon's going to ask the last question.
The last question, which I'll ask of Eric, but I'll ask a follow-up, which Valerie and Russ can take a crack at really quickly if they're interested. So the question is, and the verb is important, how do you handicap Sigma's ability to withstand a full-on constitutional challenge? So Eric, you have to give odds. You have to actually handicap it. But the way I actually would rephrase the question, and I'm curious if after you answer the question, I would invite Russ and Valerie to chime in, is whether you have any serious concerns about the constitutionality of Sigma.
Well, yeah, in contrast to the question I got about federal rights and all that, I can answer that. No. Water is, owned by the state and held in trust for the people of the state of California. The most anyone ever has to it is a use right. And there's clearly the ability of courts and the legislature to regulate that use. So could, in a particular circumstance, that use regulation go too far? We have not really seen that in the water rights context. There are two specific cases where takings have been found. Those are contractual surface water cases. I think it's very difficult in the common law water rights context because it's a use standard and because of the flexibility of the standard of reasonable use. But I'm not going to rule out there might not be a specific instance where it could be so draconian, it could be a taking. But in terms of the wholesale unconstitutionality, I don't see that. So long odds, Leon, whatever those are, very long odds.
Yeah, I would use this as a shameless plug for a law review article I wrote several years ago called the Golden Rule of Water Management. And the golden rule is, we follow water rights priority, but it had an asterisk actually in the title, and the asterisk is achieving societal welfare. It's that water management is this constant push-pull between private interest and public interest, and anytime we try to elevate one over the other and not recognize that it is this balancing effect, which, reasonableness is the name of the game. I personally think that the lens I like to look through is reasonable and often investment-backed expectations, language that you can pull from the takings doctrine in U.S. constitutional law. If we treat individual actors fairly based on what we would expect them to be treated in the circumstances, noting that expectations need to adopt and evolve over time with changing societal norms and data and understandings. But if we treat people fairly in how we go about management, there's likely to be no constitutional problems there. If you violate those reasonable investment-backed expectations, I think you have potential discrete takings challenges there. I don't think that rises to a constitutional standard for challenging SGMA as a whole. Water rights are not absolute. They're effectively a social contract. If you do what is right by the state in the use of the water, you have a private right of use. When your right is no longer consistent with the overall social utility, you no longer have a right to begin with.
I agree, and a much shorter answer, but I think same in spirit is, as applied, it could be applied perfectly consistent with the Constitution. So I don't think a challenge to SGMA for the constitutionality is going to work. But the more interesting question is how that is applied and which GSPs will be challenged and which ones will be deemed compliant and not gone too far, and which will be struck down and have to try again. So I think to me, that's the more interesting question.
So everybody, please limit your wagering to sports and not constitutional challenges to SGMA.
I'm going to keep it interesting. No. Thank you so much, everyone, for your thoughts. We've had so many great questions come in, and I apologize for those questions that we didn't yet get to. I want to just give our panelists a few minutes to offer any final words of wisdom, last thoughts based on our conversation today. And of course, the discussion by no means is over. We need to continue to grapple with some of these questions, and that will go on into the future. But thank you so much for your time. And then maybe we'll reverse the order, and I'll let Eric go first, and then we'll go from there.
I guess I just pick up on the societal issue that Russ raised and the complexity of this, because there are, and I've been fortunate to have the chance to do water outside the US in a number of different places. And when you look at the challenges we face in California, which is basically 40 million people, most of whom live in this wonderful Mediterranean climate towards the southern part of the state, which is also phenomenal, one of the best places in the world to grow things, there are going to be tensions. You have Southern California, you have Silicon Valley, and the economic value of those areas obvious, and you've got the Central Valley, tremendous agricultural ability. I'll put it in a comic context real briefly, and then the serious piece. I was looking at Russ's slides, and I was teasing him a little bit because I usually represent the prescriptors, the public water suppliers, and he's got the jailbird running off with this bag of money, and I said it should be Robin Hood. But it's these are serious issues, because farming and agriculture are incredibly important, not just California, but the United States and the world. And needless to say, drinking water for people and for Silicon Valley and other things in California, industrial purposes, is very important too. So these are tough issues. And I guess I would just close with what I always say. Despite the fact that, of course, it is a positive thing economically for lawyers like me to go through decades-long adjudications, I always encourage people to work it out. Because like I said, if you go to court, you're going to spend a lot of money and you're not going to get 100% of what you want. So to the extent you can work it out as much as possible with the GSAs, be flexible, listen to your stakeholders and work with them as much as you can. It'll benefit everyone in the long run. That would be my message.
Russ or Valerie?
Sure. I think if we're going reverse order, I definitely agree with everything Eric said. I do want to return to one substantive point that was discussed earlier and kind of weave it together with what we were just talking about. That's this issue of geographic specific reductions in a basin, and whether or not different allocations, whether or not you're close to the seawater intrusion front, subsidence, et cetera, the cone of depression. I think that we need, in that discussion, we need to distinguish between individual allocations and physical solutions. And I think often we're going to have to find ways to treat those folks that are closest to the problem fairly with everyone else. You know, DWR defines these as basins. We know they're not complete bathtubs, but they do put boundaries on them. And Valerie's absolutely right that reasonableness is the name of the game, and it is site and time specific in the sense that it changes over time. But I think it would be unfair. It would violate that investment-backed expectation. It put a disparate burden on an individual user if you said you just happen to be located near the problem place, or vice versa, you just happen to be a long ways from the problem place, and so you get disparate allocations. I think the basin as a whole, funding solutions, physical solutions to find that balance and fairness is going to be key. It does remind me again going to the takings doctrine. The Supreme Court of the United States has once said that a takings is a burden placed on an individual, which in all fairness, the public at large should bear. That same premise should apply in many respects to a basin allocation issue. If you're placing a burden on a discrete individual just because of their circumstances and their pumping regime, that is not necessarily holistically their own, but we're in a basin and everybody's pumping and causing the problem. If you're putting the burden exclusively on them, you probably have a challenge. As going back to what Eric said, trying to find equity, trying to find something for everybody, that's going to be the circumstances that's likely going to win the day, at least efficiently and effectively.
Thanks, Russ. Valerie?
Yeah, I think that's true. And another, I think, sneaker of a challenge that we're all going to see going forward is the concept of developed water. I think there's going to be a lot of claims on water that is either imported or developed that historically, has been abandoned into the system. And, as we move to management and SGMA and allocations, as those rules apply, people may apply the rules differently and take more credit for a lot of the imported and developed water. So, we're going to have to deal with not only the overdraft that we have, but potentially a shrinking native common supply to divvy up. So I think that's going to be an issue that's going to create, even more challenges moving forward for sure. And I think that there's no doubt there'll be cases about the extent to which you can claim that. So that's kind of a substantive issue that I see coming down the line as well. But I agree with everyone that most people think that they have a better right than they have, and that it's really protected and it's really senior. Collaborating and kind of taking a step back and realizing that everyone else believes in their competing right almost as much as you do, hopefully brings people to the table.
Thank you all. Thank you, Eric, Russ, Leon, Valerie, Rana. I'm so appreciative for your time. Rana, if you could just put up the final slide one more time. I want to put the CLE code up, and we'll also show the links to where the recording will be posted. We're going to post it on our EDF SGMA page. We're also going to post it on the Groundwater Exchange, which is a great resource for all SGMA related resources. And I want to give a plug to another webinar that EDF is hosting with some of our partners, Westwater Research, Szeptycki, and others on a project that we're working on in Kern County in Rosedale, Rio Bravo, to develop a open source water accounting and trading platform. So if you're interested in that, please join us on October 28th. And then the link to that webinar is there. So closing 11:29, 1 minute ahead of schedule, which is pretty impressive when we have 3 practicing attorneys on line with us. Great answers, really educational, and I hope everyone enjoyed the session today. I hope you have a wonderful afternoon.
Thank you. Thanks for having me.
Thanks all. Thank you, Christina.
Thanks. Take care all.